Let me start with a serious question. What happens when the president orders the military into American cities without the consent of state leaders? That is not a movie plot. That is not a foreign country. That is the United States, and it is happening right now. I'm Sarah, and today on Legal Logic, we're breaking down why the Supreme Court stepped in to stop a proposed military deployment inside U.S. cities, and more importantly, what this means for your constitutional rights. This case is not about politics, it's about power. Who has it, who limits it, and why the Constitution was designed to slow presidents down when civil liberties are at risk. According to the U.S. Constitution, the federal government has power, but not unlimited power. The founders were deeply afraid of one thing: a standing army enforcing domestic law against civilians. That fear is why we have the separation of powers, federalism, states versus federal authority, and strict legal limits on military use inside the U.S. The Supreme Court's action reminds us of a core constitutional principle. The military is not a police force. Let's start with the law. Under Article 2 of the U.S. Constitution, the President is the Commander-in-Chief of the Armed Forces, but that power is not absolute. Congress, not the President alone, controls when and how the military can be used domestically. That's where federal statutes come in. One of the most important laws here is the Posse Comitatus Act of 1878. According to the U.S. Department of Justice, this law generally prohibits the use of the U.S. Army and Air Force to enforce domestic laws. The logic is simple. Soldiers are trained for warfare. Police are trained for civilian law enforcement. Mixing the two threatens civil liberties. Unless a specific legal exception applies, federal troops cannot patrol U.S. streets or perform police functions. So how can a president ever deploy troops domestically? That authority comes from the Insurrection Act of 1807, a real and existing federal law. According to the U.S. Code, Title 10, the Insurrection Act allows the president to deploy military forces only under narrow circumstances, such as when states request assistance, when state governments cannot or will not protect constitutional rights, or when rebellion makes federal law impossible to enforce. Here's the key point, and this is where the Supreme Court stepped in. The Insurrection Act is not a blank check. The Supreme Court has long held that emergency powers must still follow constitutional limits and are subject to judicial review. In this situation, the court examined whether states had actually requested federal troops, whether existing law enforcement had actually failed, and whether the deployment met the strict legal thresholds set by Congress. And the court said, not so fast. By temporarily stopping the deployment, the Supreme Court reinforced a crucial rule. Presidents do not get to decide alone when constitutional limits disappear. Now, an important reminder. Laws vary by state. National Guard authority, emergency powers, and state cooperation differ in places like California, Texas, Florida, and New York. Some governors can authorize deployments quickly. Others require legislative approval. This case involves federal authority, but state law still matters, and that balance is critical. This is not just about one president. This ruling affects protest rights under the First Amendment, protection from unreasonable force under the Fourth Amendment, and the balance of power between states and Washington. If the military can be deployed without strict limits today, it can happen under any administration tomorrow. That is why the Supreme Court's role matters. Now let's go deeper, because this is where most people, and frankly many commentators, get the law wrong. The biggest misunderstanding I hear is this: if the president is commander-in-chief, he can send the military anywhere. That sounds logical, but it is legally incorrect, and the Supreme Court has said so repeatedly. One of the most important cases you need to know is Youngstown Sheet and Tube Co. versus Sawyer in 1952. According to the U.S. Supreme Court, the president cannot seize power simply by claiming an emergency, even during times of national crisis. In that case, President Truman tried to seize steel mills during the Korean War. The court said no. The legal logic was clear. Emergency does not create power. Power must come from Congress or the Constitution. Courts remain a check, even in crises. That logic still governs military deployment decisions today. Let's return to the Insurrection Act of 1807, now codified at 10 U.S.C. ISA 251-255. According to the statute itself, the president may deploy troops only if a state requests help, or state authorities are unable or unwilling to protect constitutional rights, or federal law cannot be enforced by normal means. Here's the trap, though. The president must make a factual, legally supportable determination that these conditions exist, and courts can review that determination. The Supreme Court's intervention signals concern that state law enforcement was still functioning, governors had not requested assistance, and constitutional thresholds may not have been met. That matters, because using troops without meeting these conditions violates congressional limits. Another common legal mistake is confusing the National Guard with federal armed forces. According to the National Guard Bureau and Title 32 of the U.S. Code, governors control the National Guard unless it is federalized. Guard members can perform law enforcement under state authority, but once federalized under Title 10, they become federal troops, and Posse Comitatus applies. That means arrests, searches, crowd control are heavily restricted unless an exception applies. This legal distinction is central to why courts scrutinize deployments so closely. Let's look at history. In Little Rock, Arkansas, in 1957, President Eisenhower deployed federal troops to enforce school desegregation. Why was that legal? According to historical DOJ records, state officials actively blocked constitutional rights. Federal court orders were being defied, and local authorities refused enforcement. That met the Insurrection Act standard. Similarly, during the 1992 Los Angeles riots, federal troops were deployed after California's governor formally requested assistance. The legal logic worked because state authority failed, a request was made, and Congress's conditions were satisfied. In this current situation, the court questioned whether states had lost control, whether constitutional rights were being denied by states, whether federal law enforcement had actually failed. Without those facts, the legal foundation collapses. So that's why this matters to you, because emergency powers expand fast, but history shows they are rarely given back easily. This is not about stopping law enforcement. It's about stopping unchecked power. The Supreme Court is signaling that presidents must follow congressional limits, courts remain active during emergencies, and civil liberties do not vanish under pressure. Let's bring this together, step by step, using legal logic, because when you strip away the headlines and politics, this Supreme Court action follows a very clear constitutional formula. According to the U.S. Constitution, no single branch, including the president, holds unlimited authority. Article 2 makes the president commander-in-chief, but Article 1 gives Congress the power to regulate military use. Article 3 gives courts the power to review executive actions. This balance is intentional. Congress passed real laws to control domestic military use. Posse Comitatus Act of 1878, according to the U.S. Department of Justice, it generally prohibits the use of the U.S. Army and Air Force to enforce domestic laws. Insurrection Act of 1807 to 10 U.S.C. 251 to 255 allows military deployment only under strict specific conditions. The logic here is simple. Military force inside the U.S. is a last resort, not a first response. The Supreme Court does not ask, is this politically popular? It asks, did the president follow the law Congress wrote? In this case, the court questioned whether states had actually lost control, whether governors had requested help, and federal law enforcement had actually failed. Without those findings, the legal foundation collapses. That's why this matters to you. Because emergency powers expand fast, but history shows they are rarely given back easily. This is not about stopping law enforcement. It's about stopping unchecked power. The Supreme Court is signaling this. Presidents must follow congressional limits. Courts remain active during emergencies. Civil liberties do not vanish under pressure. Let's bring this together, step by step, using legal logic. Because when you strip away the headlines and politics, this Supreme Court action follows a very clear constitutional formula. According to the U.S. Constitution, no single branch, including the president, holds unlimited authority. Article 2 makes the president commander-in-chief. But Article 1 gives Congress the power to regulate military use. Article 3 gives courts the power to review executive actions. This balance is intentional. Congress passed real laws to control domestic military use. Posse Comitatus Act of 1878. According to the U.S. Department of Justice, it generally prohibits federal troops from enforcing civilian law. Insurrection Act of 1807, 10 U.S.C. sections 251 through 255, allows military deployment only under strict, specific conditions. The logic here is simple. Military force inside the U.S. is a last resort, not a first response. The Supreme Court does not ask, is this politically popular? It asks, did the president follow the law Congress wrote? In this case, the court questioned whether states had actually lost control, governors had requested help, and federal law enforcement had truly failed. Without those facts, the legal threshold was not clearly met, so the court stepped in, exactly as the Constitution intended. This ruling protects First Amendment rights, protest and assembly, Fourth Amendment protections against unreasonable force and searches, and state authority to manage local crises without federal overreach. Most importantly, it protects the idea that emergencies do not cancel the Constitution. Every administration, past, present, or future, is bound by the same legal limits. What you should watch for next. Whether Congress clarifies or amends the Insurrection Act, how courts define failure of state authority going forward, and whether future presidents test these limits again. Legal power expands quietly, and that's why understanding the logic matters. This Supreme Court action is not about stopping security. It's about preserving liberty while maintaining order. That balance is fragile, and it only survives when courts enforce the rules. That is legal logic. If this video helped you understand how constitutional power actually works, subscribe to Legal Logic. We break down real U.S. laws, real court decisions, and real rights without fear, without politics, and without confusion. Like this video, share it with someone who cares about their rights, and stay informed, because knowing the law is the first step to protecting yourself. I'm Sarah, and this is Legal Logic.